I wanted to talk about the concept of non-material damages. The concept is crucial because if you understand the non-material damage broadly, you have a lot of cases where such a damage arise. If you interpret it very narrowly, there are not too many cases. So the financial risk for companies is linked to this concept. This is why it's so interesting. And the ECJ ruled that one possible non-material damage is the fear of potential misuse of personal data. And national courts have to verify that these fears are actually well-founded and that the affected person has suffered negative consequences. Now, German courts are really struggling to find out whether these fears have been well-founded. And the FCJ made it even more complicated because the court ruled that national courts have to summon the claimant or the plaintiff to the oral hearing and to hear the plaintiff in court. This is very time-consuming and also not very pleasant for the plaintiff, to say at least, because many plaintiffs followed these advertisements and they were not ready to talk about their fears. So they have to answer all these questions from the court and also from the defendant lawyers. So what I, as a defendant lawyer, always ask is, how did you feel after the data breach? Can you provide another example of your life where you have suffered similar fears? How does it feel in your body? Have you changed something after the data breach? I have Googled you and I found that you have shared your grades from university on Zing. How important is privacy in your life? And the plaintiffs often have like a paper in front of them from their law firm, and they say, okay, I was very scared, but in many cases they are not able to prove that these fears were real and well-founded. So some or a lot of claims failed at this point. Now there is another possible damage that the ECJ constituted. It's the loss of control. The ECJ stated that the loss of control may constitute non-material damages. So it was disputed in Germany, is the loss of control itself a damage, or does it only follow from the loss of control? It's an important difference. And the FCJ now stated that the loss of control itself is a non-material damage. This gives the plaintiffs a very straightforward basis to claim because they only have to show that there was a loss of control. We don't know what the loss of control is. The court has not provided any definition of this. The FCJ has only ruled in one case. It was in the meta scraping case, where the affected individual or the phone number of the affected individual was published online. And the FCJ stated that since the individual has only gave the phone number to a small group of people, and the phone number is now published on the internet, this difference constitutes loss of control. So we now see in Germany that plaintiff law firms tend to claim for loss of control rather than for fear, because they realize it's not too good to have the hearing in front of the court and not very successful. And it's much easier to base claims on loss of control. The ECJ has also ruled or gave guidance on the question how courts should determine the damages. And the ECJ stated that the assessment of damages is to be based on the member state's law, but in compliance with the principles of equivalence and effectiveness. And from the principle of effectiveness, it derives that the compensation of damage must be full and effective. So courts have to find an amount that is sufficient to compensate. There is no certain threshold of seriousness, so every damage has to be compensated, and the claim doesn't have a punitive or deterrent function. So compensation only. But compensation is not that easy because we have no numbers. We have the first judgment from the Federal Court of Justice on this scraping case, loss of control over a phone number, and the FCJ stated that an amount of €100 for this loss of control could be appropriate.